We'll make a start now. My name is Heather Roberts. I'm an Associate Professor at the ANU College of Law, and I'd like to welcome you to this virtual Visiting Judges event. I'd like to acknowledge and celebrate the first Australians on whose traditional lands the ANU is placed, and pay our respects to the elders past, present and emerging. And I'm sure I speak for all of us when I say it will be wonderful to be able to gather physically on ANU campus again when it's safe to do so. And in the meantime, I hope that everyone is staying safe and well. Today, I have the particular pleasure to welcome two graduates of ANU Law to speak with us today. The Hon Justice Alan Robertson has been a long-time friend of ANU Law, sharing his time and expertise with us on many occasions. After his graduation, Justice Robertson worked in the Commonwealth Public Service in Canberra for a decade, including at the Attorney General's Department, before moving to Sydney, to the bar and developing an extensive practice, particularly specialising in public law. In April 2011, he was appointed to the Sydney Registry of the Federal Court of Australia, and we're particularly grateful for him making time to speak with us this week, as it's his final week before retiring from the court. Today, Judge is joined by another ANU graduate, Will Randles, who has been Justice Robertson's associate since 2019. Will's worked at the Australian Government Solicitor and at Ashurst, and I'm going to hand over to Will now to have a conversation with Justice Robertson about his life in the law. Over to you, Will.
Hi all, I'm Will. This is Justice Robertson, and I'll be asking questions today. I hope I get some answers.
We should say where we are. We're on level 21 of the courts building in Queen Square in Sydney, and looking at the rather splendid view of Hyde Park and the surrounding buildings. And as Heather explained, I'm in my last week as a judge of the Federal Court because the Constitution says that federal judges have to retire on their 70th birthday, which in my case is on Sunday. So I'm going to have a virtual farewell ceremony on this Friday.
Which we're all looking forward to, Judge. I thought we'd start with your time at ANU, and in particular with a couple of questions that have been sent in that are of particular interest to students. So the first student question is, what first interested you in law? Did you have any close family or friends with a background in the profession?
I think the answer to the first part of the question is that, as Heather mentioned, I was working in the public service, and the area that I was working in had to do with both policy development and law. At that time, I had an arts degree, didn't have a law degree, but I was getting a lot of advice from lawyers, so I needed to understand better what they were saying and whether what they were saying was right. I had to read a couple of decisions, High Court decisions, New South Wales Supreme Court decisions from national security days of the Second World War. I was intrigued by the reasoning of the judges, so all of those reasons I decided to study law. That was already unrelated. It was only in hindsight that I realised that my father had been a member of Gray's Inn. He was in the Navy, but he also studied and been admitted as a barrister. And then on my mother's side, my grandfather, as it turned out, I wasn't really aware of this either, he practiced as a barrister in the High Court in Calcutta from about 1900, whatever it was. So as it turned out, although I think unrelated consciously, maybe subconsciously, that had something to do with it as well.
Maybe it runs in the family.
Could be.
Do you have any favourite moments from your time at ANU, Judge?
Well, it was all very serious, and the problem was, I think, that I studied the first 3 years of part-time, which I wouldn't really recommend. I think you get much more out of it if you can organise things so that you can study full-time. But I met a lot of people who became sort of long-term friends and colleagues. There are a lot of ANU graduates, as you'd all know, at the Sydney Bar, more than a handful on the New South Wales Supreme Court and on the Federal Court. I kept in touch with all of them. I think that's, and of course the enjoyment you get from good lecturers, but I think it's important to get what you can. I think it's part of the educational structure, if you can arrange it, to spend a lot of time with the other students. I think that's all part of the learning process.
You studied part-time. Was there any particular way in which you approached your studies, and are there any lessons that you've learned over the years that you wish you'd known at ANU? That's another student question.
Well, I don't know where the emphasis is these days, but certainly the emphasis in those days, I'm talking about the mid-1970s now, there was a lot of emphasis on exams, but studying part-time, I tended to take sort of annual leave, and do a bit of cramming just towards the exam time, which is probably not a good idea. I don't know how exams are structured. In those days, Professor Zines received a lot of complaints about how difficult the exams were and how short the time was. So one year he experimented and said, well, you can stay as long as you like in the exam. And some students actually stayed doing the constitutional law exam. I think the last person left after about 7 hours. So if you now have finite times for exams, I think you count yourself lucky. But so I got a lot more out of it the final year when I did it, studied full time, kept up better with the program as it evolved, rather than cramming at the end. One thing I've learned over the years in practicing law is, and you don't get much of it at law school, probably, is the importance of facts. You tend to get more, I think, legal principles, which is fully understandable, but the deciding cases, anyway, all turn on their own facts. So you need to be fully aware of what the factual basis was for what the judges said in the judgments. Obviously, if you're dealing with statute construction, well, then you're dealing with facts of a different sort. You're probably dealing with facts which the person who wrote the statute hadn't thought about at all, which is why statute construction can be difficult.
Another related student question is whether you have any tips for law students of today.
Well, look, I don't want to pontificate too much because I think probably law schools of the present are very different from law schools of the 1970s. I've always encouraged students to read, so far as possible, read entire cases rather than the extracted principles that I referred to just now, which you'll find in a case book. You can't do that all the time, obviously, but it's you get a lot more value out of the case if you pick up on the facts and the procedure as well. So I think try and do that as far as possible. I think immersing yourself in each of the subjects rather than trying to do, in a sense, what you can get away with, the minimum. That's difficult for people who study part-time in particular. But as I've said, I think I got a lot more out of the final year, which I studied full-time, immersing yourself, spending more time on campus, talking more to fellow students, I think is the lessons that should be borne in mind.
After you finished at ANU, you had an illustrious career and a journey, some might describe it as, which has landed you in the destination of the Federal Court of Australia. Hopefully not your final destination, Judge, but I was hoping you could sketch out the course that journey took.
Yes, I'm happy to do that in outline. I think it's maybe giving it more certainty and structure than it deserved to say it was a journey, because that sounds though it knows where I was going to end up before I started. But obviously there are choices that you make, some conscious choices, some choices that perhaps subconscious, you don't realise that you're making choices, but every time you decide to do something, well then there's a lot of other things you've decided not to do. So I didn't start studying law really till I was 25, as I've just described, but I did my arts degree and then didn't study at all for 3 years or so. So I became interested in Commonwealth constitutional law, being taught by Professor Jeff Liddell and Leslie Zines and Gary Rumble. Then I wrote an honours essay on the constitutional law topic called The Effect of Unconstitutional Statutes, which hadn't been written on at that time. And then that put me in good stead to do some teaching, both at the ANU and at what's now the University of Canberra. Then I joined the Commonwealth Attorney General's Department. Then I worked in what was then the Advisings Division, which was largely constitutional law, with Dennis Rose. And on the strength of all of that, I was chosen to work as counsel assisting the Commonwealth Solicitor General, which was obviously largely constitutional law. And then I moved out of salaried employment at the Attorney General's Department to private practice in the New South Wales bar. The other choices, possible choices, were the bar in Canberra, but that was very small at the time, or the bar in Melbourne, but I was more familiar with Sydney. And that coincided, luckily, with the time that I could afford to do it. Then, as I say, I went to the private bar. Those days the bar exams weren't too onerous or difficult. And so on it went. And then the important choices then, you're thinking of going to the bar, then and now I think, was choosing someone to read with. You know that you've got to read, be supervised in a sense for your first year or so at the bar. So you want to choose a tutor, pupil master who's got a practice in the area or one of the areas that you're keen on pursuing, and you need to find yourself on a floor of barristers, and so on it goes. Life at the bar, accepting any brief that you're offered in the early days, and then being more discriminating, and doing your work on time and doing it well, I suppose, are essentials to life at the bar.
We have some questions on how to be a good barrister, which we'll get to, but in the meantime, we have a student question that's been submitted through Microsoft Teams. The student asks, I note that that Your Honour read with Justice Gummow, then William Gummow, when starting at the bar. What role did Bill Gummow have as a mentor in your life, and what advice would you give for benefiting from mentorship?
Well, I think mentoring is very important because the mentor can give you advice about their experiences and so on, help you to avoid pitfalls, point you in the right direction and so on. He at that time had been a partner at Allen's. He hadn't been at the bar for that long, probably 6 or 7 years, I'd imagine. But he had a public law practice, constitutional law practice, which is where I met him in Canberra. He also had, obviously, an enormous equity practice, having been one of the authors of Margot and Mahang, obviously. But he also had a very large intellectual property practice. So all of those things stood me in good stead, because the system is, with a the New South Wales bar, and I think other bars, is that whoever you read with gives you deviling to do, so opinions to draft, pleadings to draft, and so on. So you get good practical experience, hands-on experience, which you probably won't have had until that time. But I think it's important, to go back to the other part of your question, to have people more experienced than you are, that you can take issues to, chat to, take problems to, and then they can give you some guidance. I think it's important to have a figure or two like that in your life.
Thanks, Judge. What were some of your favourite aspects of life?
Well, I think, I mean, in those days it was a lot smaller and it was more collegiate, I think, than it is now. I mean, now I think there's about 2,300 barristers at the bar in New South Wales. There's no longer a common room where people mingled and so on. I think working with other like-minded lawyers is one of the great benefits. When you're a team on a larger case, you've got a couple of solicitors, you may have 2 barristers and so on, and working together to solve a problem or to work out how best to present a case in court, I think is pretty rewarding. So that's what I think I'd point to first. And of course, that doing that means that you make a lot of strong friendships. Depends a little bit, I suppose, on the size of the floor that you're on, how many people are on the floor. I started on a large floor which had about 25, 28 barristers, and I ended up on a floor with only 5 other barristers. So that makes a difference as well. But as I say, I think it was sort of more compact. The bar was more compact, more cohesive than it is now. But I still think those benefits, those aspects of life are still available. So you're surrounded by other, ideally, hard-working, intelligent, like-minded lawyers, which is not to say that you're not in competition with them. You are. You're in competition with them for a brief, I suppose, in a general sense. And then you're also, as often as not, opposed to people that you know, you've been opposed to them before, you've been on the same side before, and so on. So all of that is intellectually satisfying.
And just one more question on life at the bar, and this is already covered a little by your comments on your tutorship by Will Gummo. But what was your experience of mentorship and collegiality at the New South Wales bar that it's often held up?
Well, I think I probably covered that. I mean, what I haven't mentioned is that I think most barristers have an open door, in the sense that any other barrister can come and see them and discuss issues, problems with them. I think the collegiality, what I was trying to say before, is it's not any longer probably bar-wide, if it ever was, but more focused on particular groupings.
Did you have any pupils before you took silk?
Yes, I did. I had, in fact, I had a special dispensation because normally I think you're not allowed to take pupils until you've been at the bar for 7 years, I think it is. But I actually had my first pupil when I'd been at the bar, I think, for 6 years. But he was such an illustrious pupil that I was allowed to have him, because he's now Justice Gaegler of the High Court. So he was a powerful intellect even then. But I had probably 6 or 7 pupils, because starting then, and then I took silk after, say, 12 years at the bar. So there was another Five or six, yes.
So did you have one every year?
One or two, actually, in some years. I think that's an excellent system. It depends on when you come to the bar, it depends on what you've done before. Obviously, some people have been a solicitor for a long time. Some people haven't. Some people are straight from law school, more or less. Some people from postgraduate law. But nothing beats getting your feet under a table and standing up the bar table in court and actually solving problems and running cases for yourself.
So as I foreshadowed, Judge, we do have some questions on being an advocate.
Mm-hmm.
And in short, what do you think makes a good, successful barrister or advocate?
Well, I think there are a number of things that you can say about that. I gave a talk, I think last year, to some of the junior barristers on one of the chambers next door in Wentworth Chambers. Without going through them all or in any particular order, I think the first thing is that if you're going to build any sort of practice, you've got to do your work, whatever it is, and do it on time and accurately and as well as you're able. And I don't think you should behave in court any differently to how you behave ordinarily. I think people who have a sort of different manner in court, I think judges sort of quickly see through any element of sort of artificiality. And I think you really need to be independent. That's easier to say than it is to do. I think a lot of junior barristers think, oh, look, I can't run this point because the solicitor doesn't want it run or whatever it might be. I think you've got to establish a reputation for independence, draft your own submissions, be in control of the case, and over the years you'll build up, ideally, a reputation for being trustworthy, independent, competent, candid with the court, and you've got to build up a relationship with as many individual judges as you can. I think that's why having an independent bar or specialist bar is important, because that's what you do, is you run cases in courts.
Do you have any memorable cases from your time at the bar?
Well, I've thought about that. Some are memorable in different ways. One of my favourites was a case called Telstra and Worthing, which turned out to be a Section 109 case. But
It's 109
109 Constitution. I was appearing for Telstra. I lost at first instance. I lost 3-0 at the New South Wales Court of Appeal, and to my great satisfaction, I won 7-0 at the High Court. So I thought I must have the wrong end of the stick at one stage, but luckily it turned out not to be the case. So that was satisfying. If you win a case for an individual in straitened circumstances, that's very satisfactory too. There was a case where I was acting for a doctor called Dr. Samad, and again we lost in the New South Wales Court of Appeal, but one, I think it was 5-0, I can't remember, in the High Court. That was satisfactory. And then one other case, but probably procedurally odd, which sticks in my memory, is a case called Linter Textiles in the High Court, which is a tax case. What was odd about it was that I was only briefed to appear when the case was part heard in the High Court. And fortunately, as it turned out, or luckily, my client lost on all the points that had been argued until the time I came into it. But ultimately, we succeeded. But it's quite difficult to pick up the threads of a case that's half argued in the High Court. So that was a bit more of an intellectual challenge, I think, than I wouldn't want to repeat that circumstance more than once, I don't think.
Moving then to your appointment to the bench, what made you think that the time was right?
Well, I think for most people, once you've done something for a number of years, you're looking at other opportunities, really. If you're getting to the stage where you think, oh, well, I've done this before. And then I think as well as an element of trying to look at things from, as it were, the other side of the bar table. So you're no longer running a particular line. As a judge, of course, you don't, in a sense, care what the outcome is. You've got no particular interest in the outcome other than trying to get it right. So it's a question of when you can afford to do it as well. I think it comes with a particular age. Your juniors are getting younger and younger, and you're not. So I think for those who want to become a judge, I think the day dawns and you think, well, I'll look at whether there's a court I can be appointed to, and I think all those things coalesce. I've been a silk at that stage for about 16 years, I think. So I think the time was right, really.
Fair enough. And for those wanting to become a judge, is it true that most judges are appointed from the bar?
I think it still is true. Most judges to, say, the federal court, the Supreme Court, etc., are not so much to the district court, not so much to the local courts. Increasingly, I think, with the federal court and the Supreme Court of New South Wales, you get a bigger representation of those who practiced as solicitors, much more than, say, 15, 20 years ago. And some, of course, the people who practiced as solicitors have made outstanding judges, like Justice Lehane, for one, who was the judge of the federal court, one of the trio I mentioned before, Margot Lehane, Justice Barrett of the Supreme Court of New South Wales, and also, of course, academics are appointed. The case, most eminent case in the federal court was Justice Paul Finn, formerly of the ANU. So things have loosened up a little bit, not as much as the solicitors would want, but increasingly the bar is not the only source of appointments.
Do you have any perspectives on being a judge? For instance, so maybe you could speak to some of the differences between courts in Australia.
Yes, I think people talk about being a judge, but I think if you reflect on it for a moment, they're really very different types of judging, partly dictated by the sheer volume of cases that a particular court, judge on a particular court may have to deal with. I mean, say if you think of the local court, judge at a local court, they deal with hundreds, if not thousands of cases a year. Whereas if you go to the other end of the spectrum, High Court judge probably only has to deal with, I mean, obviously the larger, more complex cases, but they probably only deal with maybe 50 to 60 a year, leaving aside applications for special leave. The district court or the county court in Victoria would be somewhere in the middle. So I think the numbers dictate what judges do. Of course, they're all doing the same thing in a way, which is finding facts, applying the law, or hearing appeals, etc. So it's not right, I think, to treat all judges as though they're doing exactly the same thing. And in the federal court, of course, you do very little crime, which takes up a lot of what the New South Wales Supreme Court does, and the Court of Criminal Appeal. We do next to no crime at the moment, although there is now some criminal jurisdiction. So the federal court's jurisdiction is very diverse, from admiralty, native title, intellectual property, administrative law, constitutional law, very diverse, but more perhaps specific than the general law jurisdiction of the Supreme Court.
And have you seen any shifts in the role of the federal court over time?
Well, of course, its jurisdiction has changed very substantially to when it was set up in the 1970s. Really, any matter arising under a Commonwealth Act or Commonwealth statute is now part of the court's jurisdiction. There are many more specific pieces of legislation. And I think the number of cases, to go back to that topic, has increased. The number of judges, of course, has increased. And I think it's a lot busier. There's much more case management than there used to be, consistently with the trend in other courts as well. The docket system was introduced now probably 15, 20 years ago, which was all part of the case management. So I think a lot more cases, a lot more management by the court, and probably less time, because there are more cases, less time to spend on individual cases. For example, I think if you go back to the 1980s, you had a full court case, you'd probably find 3 judges writing 3 separate judgments, whereas now it's much more common for a full court. I'm not saying it's invariable, but it's much more common to have a single judgment of the court, and of course there are arguments pro and con whether that's a good thing or not.
We had a student question about that, Judge. Do you have an opinion on whether it is a good thing or not?
Look, I think I mean, in the High Court, there are different views. I think the Chief Justice encourages joint judgments because that's because it's more efficient. People against that view says, oh yes, but you lose the nuances and so on. But I think in nuances of differences of opinion, different shades of opinion and so on. But I think that most people probably quake a little bit if they've got 7 judgments to read and they have to work out what it is that's common ground and what it is that isn't. I used to be a law reporter many years ago for the Australian Law Reports. I remember in those days some of the High Court judgments, 5 judgments, 7 different judgments. It was a very large task to find what the common thread was. So, and I think there's even less reason in intermediate courts of appeal to have disparate judgments, but all coming to the same conclusion. Obviously, if there's a dissent, then it's got to be a separate judgment. But I think it's overall it's better to have a single statement of the dispositive reasoning in a particular case.
I've got a few questions on your work as a judge. Are there any parts of the job that you find less attractive than other parts?
Well, I think the case management aspect, getting the case from the time it's filed to the time of judgment in the shortest possible time. Sometimes that's satisfactory if it all goes smoothly. Other times it feels more like you're managing the diaries of the busy lawyers who are appearing before you who can't do a case or can't do something in a case this month or next month. I myself didn't find that particularly rewarding, the case management aspect, but it is necessary and essential to maximise access to justice, minimise costs and so on. So,
are there perhaps other ways that you've done that by a registrar or similar?
Look, I think so.
I think maybe in Victoria they have quite a lot of case management registrars.
I think they do. I think in Queensland as well they do. But there is some benefit in parties being able to have ready access to the judge who's actually going to decide the case. You get that continuity, and there isn't that element of, oh well, maybe the docket judge will think something different. But look, overall, the work of the court, I think, is very intellectually satisfying, both first instance work and full court work.
I was hoping maybe you could speak to some aspects of that work, first instance and full court work, and maybe some of the differences between.
Well, I think with first instance work, obviously the time spent on what I call court craft, that is running the court, is a lot more pronounced because the facts are still at large. So a large part of a trial, and a difficult part of the trial for the judge, is ultimately to make findings of fact where they're in dispute, and to make findings of fact as precise and as detailed as possible in case the matter goes on appeal. Full courts, occasionally, of course, you're asked to review findings of fact by the trial judge, but generally they are more concerned with matters of principle. And then, of course, on full courts, you also have the benefit of interacting with the other two judges, or sometimes the other four judges who make up the full court. So the work on the full court is quite different, I think, to being a trial judge. But I think doing both sorts of work is important. So I noticed that in the New South Wales Supreme Court, even the Court of Appeal judges nowadays, over the last, I think it was introduced about 4 or 5 years ago, there's a program whereby the Court of Appeal judges go down and do trial work for a month at a time, maybe once a year, maybe twice a year. And there's also a system for some of the more senior trial judges in the equity division or common law division to sit on the Court of Appeal. So I think it's important to see both sides of what happens.
Do you think the federal court was ahead of the game on that aspect? Because it's been the case since it started that judges sit on trials and appeals, hasn't it?
Yes. Well, I think increasingly, state courts, anyway, the Supreme Courts, I think increasingly they are having separate courts of appeal. In, I think the most recent one, which is about to have a separate court of appeal, is in South Australia. That's going to happen, I think, early next year. So there are obviously efficiencies to be had in having a separate court of appeal. I think one of the reasons the federal court doesn't have it is because of the geographical spread. Some of the registries only have relatively few judges. There's, I think, only 3 or 4 in Perth, 3 or 4 in Adelaide, one in Tasmania. So I think you get some unevenness and some difficulties if you actually said, well, it's going to be 6 judges who are going to be federal court of appeal judges. There are arguments both ways, but I think the system works pretty well.
What skills or characteristics do you think are important to being a judge?
Well, that's a large topic. I always used to say that you shouldn't have too many sort of preconceptions or issues. I think listening is a major skill to being a judge. Listening, I think enjoying writing is another skill that's important. I think having what I call a calm and quiet court is probably more conducive to decision making than having a sort of lot of shouting and rambunctiousness.
Even if it might be entertaining.
Even if it might be entertaining. I think being decisive is important. some people have difficulty making up their minds. I'm not saying every case is going to have an obvious answer, but I think if you reserve your judgment, think about it, write your reasons in draft, there comes a time when you get into diminishing returns and you say, look, I can just improve the grammar in that sentence or polish this sentence. I think you just got to publish it once it's in a final form. The parties want to know the answer. In trial judges, they don't want the ultimate refinement and polished phrases, and so they want to know the answer.
Do you try to give extempore judgments when you can?
Yeah, as much as I can. That involves a fair amount of work beforehand. Obviously, if you're looking at a case the first time when you went onto the bench, it would be a very exceptional case where you feel confident enough in the answer to give an extempore judgment. That's one of the benefits of the docket system, is that you are familiar with the case, or much more familiar with the case. But I think if you read the papers, read the written submissions, if there are any, beforehand, form a provisional view, and if you think after hearing argument the answer's straightforward, then I think you should give an extempore judgment just to get through the work, really.
We've had a couple of student questions about associates. Could you comment perhaps briefly on the role of associates and maybe what you look for in terms of traits or skills when you're selected associates?
Yes, I think the work of an associate is, on the federal court anyway, there's a lot of what I call administration, that is dealing with the case management matters, the timetabling, the taking out of orders, communicating with the solicitors, with the counsel on each side and so on. Just getting the matters ready. There's almost an infinite number of details that have to be sorted out. Perhaps it's worse at the moment with the remote hearings and so on. There's probably more fiddling around with making sure that people have the technology and can use it, and telling them how to use it. So there's a lot of administration, but I think as well there's still a fair amount of legal content, bit of research, a lot of proofreading, which you either like or you don't. But it's not just proofreading for typographical errors or errors in references to the evidence. There's also, I think, a sort of standard element to proofreading, testing the propositions and so on. So I think it's very good work for a lawyer, maybe a year out from law school, maybe they've done a year in a solicitor's firm. I think you learn a lot about how courts work from being an associate in a trial court. You learn different things as an associate, say, to a High Court Justice.
Maybe I can weigh in to plug the federal court on that front, because you get both, which I found immensely valuable.
And I think you get a lot of value from all the other associates who you work with, who are all about your age and experience.
It's great fun as well.
So say there's, what, these 14, 15 other associates in Sydney on the federal court?
I think it might be more like 30 these days.
30? Oh, well, that's right, because some judges now, they don't have what used to be called, executive assistants doing admin, typing and so on. Quite a few of the judges now have 2 associates because the judges adept at word processing, etc., etc. So anyway, those are people your age, your interests. A judge at the federal court spends a lot of time, you'd be glad to know, not 7 days a week, but 5 days a week anyway, with the associate, not necessarily at long stretches, long continuous stretches, but throughout the day, a lot of time spent with associates. I think most of those who make it to interview, I'm talking now about choosing associates, have got pretty solid academic records, high marks and so on. So what I tend to look for is what experience they've had after graduating outside the law school, what interest you have in matters falling within the court's jurisdiction, whether it's tax, administrative law, constitutional law, etc., that breadth of interest. I think you've also, most importantly, you've got to have a personal compatibility with the prospective associate. There's no point having somebody who you don't click with really, and you're only doing it on the basis of a sort of 30-minute interview. So you have to be pretty sure that you get it right, really.
We might ask one of the student questions, which has been sent in there are actually two questions which are quite similar. One is from Tiger Lin, and the other is from Julia Liu. Tiger asks what some of the current issues in constitutional and administrative law that you've found interesting are, and Julia's asked whether you've seen any changes in the public law landscape while you've been a judge.
All right, well, dealing with the second one first, I think I wrote a paper for the book that was published, edited by James Stelios. I think it's called 40 Years, Federal Court's Contribution to the Law Over 40 Years. And I wrote a paper in that, which was the different approaches over the decades of the Federal Court to, in particular, to fact-finding on judicial review. I think there's been a very substantial shift from pure formality, or more or less pure formality, to what I call substantive engagement with the decision-making, both as a matter of process and otherwise. So that's the biggest change I think that I've seen in the public law area of the court's jurisdiction. Emerging topics, the ones that we've dealt with recently, well, we dealt with Section 44 of the Constitution, and a judgment handed down a month or two ago involving the Treasurer, Mr. Frydenberg. So that, of course, was a hot issue for, I don't know how many cases there were in the High Court, probably 12, 15, something of that order. I think it was remitted to this court just because this court was better placed to make some speedy fact-finding, which again emphasises the importance of fact-finding in all areas of the law. We've looked at issues to do with the Governor-General twice, one in relation to the Freedom of Information Act, one in relation to the Archives Act. Both of those went on appeal to the High Court. There's the question of the reviewability of non-statutory exercise of power. So that's probably going to be an area of increasing interest, and also, of course, consistently with what the High Court's been doing, a trend to litigate questions of what I call Chapter 3 questions, and also imply freedom of political communication. I think those are the topics we've seen most of over the last couple of years. One constitutional question, or more or less constitutional question, is a full court decision I was involved in probably 5 years ago now, which was this court's jurisdiction to hear defamation cases, which has been now a burgeoning part of the court's jurisdiction, I think much to the unhappiness of some of the state attorneys general, so far as I can gather. But why do cases come to this court? If a litigant has a choice, then I think that's a good thing. In the 19th century, litigants had choices in the courts in England, and I think if people can say, well, I might get the case on quicker here, or if I go to this court, I can have have a case without a jury, or I go to another court, have a case with a jury. All of those things are, I think, available to the litigants. So, as I say, competition between courts is not unknown historically, and I don't think it's a bad thing.
I think that case that you're referring to, Judge, is that Crosby and Kelly?
Yeah.
That's in the federal court reports. If anyone would like to read it, it's a good, very interesting judgment about how the territory's jurisdiction can get moved to the federal court.
Yeah, through and a bit of a cross-vesting as well. But just as a footnote to that case, I remember asking the parties, look, are you certain that you're not going to raise a constitutional point? Because obviously they had been raising a point about, it's a defamation case involving a member of Parliament, Mike Kelly, who's just announced his retirement. And obviously if the parties had been going to raise a constitutional point, then the court would plainly have had jurisdiction. So counsel said, no, we're not going to raise a constitutional point. So we decided on a non-constitutional freedom of political communication point. So we decided that, they took it up to the High Court, special leave was refused, and of course what happened there, application to amend to raise the constitutional point. So in a sense we didn't have to jump through that particular hoop at all, but there it was.
Heather Roberts has asked whether you have any thoughts on being a judge in a case with self-represented litigants.
Yes, look, it is one of the great difficulties, self-represented litigants, difficulties for the court, because by definition the litigant isn't experienced. I've never had a case with two, I think, with self-represented litigants on both sides. So you've got that imbalance built in to begin with. You've got lawyers on one side, non-lawyer on the other. So there is an obligation on the court to explain procedures, tell the self-represented person what their choices are to some extent. I had a case just yesterday where in a previous hearing the question arose, and I advised the self-represented litigant that she didn't have to read her affidavit formally, and the consequence of not doing that was that she wouldn't be exposed to cross-examination. So I had to explain that to her. But there are different sorts of self-represented litigants. We see a lot in the federal court because of the Migration Act jurisdiction of self-represented litigants who speak very little English or no English at all. So you've got the interpreter as well as an added factor, and then another set, as it were, of self-represented litigants, a special set, are what are referred to, I think, in the writings as scurrilous litigants. So that is people who are sort of deeply unhappy about the grievance that they particularly have. I'm not trying to put them all in one category because they've got different sorts of grievances and so on, but they do cause particular difficulties. As I say, the court has to explain procedures and so on. I've found one way of, which seems to work, is explaining at the beginning what the course of the hearing is going to be, so as to provide a structure and that element of certainty to the litigant in person. If you provide a structure, say this is going to happen, then you'll have your chance to say this, and then so-and-so says that's going to happen. And that tends to smooth the running of the case, but I wouldn't say I've mastered how to run a case smoothly with self-represented litigants. And of course you get that in balance. You've got the skilled, at least knowledgeable lawyer on the one hand, and the self-represented litigant as often as not has very little legal background.
If we can be indulged to go a tiny bit over time, we've got some interesting questions from Andrew Ray that I feel like I'll ask you as a student. I hope he's watching.
Yes.
The first question is, when decisions attract intense media commentary, does this increase the pressure on judges, and how does the court respond to any inaccuracies in report?
Yes, I don't think it increases pressure, except possibly that if a journalist is particularly interested in the case, well, they'll be anxious to know what the answer is. So perhaps it has, but I don't think it increases the difficulty of a case. I can't think of how it would. Perhaps it means, as I say, that it's comes nearer the list of things that you have to deal with. I should just say, and I think all the students would know this, that contrary to what some journalists think, you don't hear one case and then decide it, and then hear another case and then decide it. There are always 5, 10, 15, 20 reserved judgments. I've worked on maybe 3 or 4 different judgments in a single day at various stages of settling the judgment, drafting the judgment, and so on. If there is misinformation in the press, we do have somebody called, I think, the Director of Public Information. But the sorts of times that the court reacts to misreporting is generally where something is said which brings into question, no doubt from ignorance rather than malice, but brings into question the independence of a particular judge or the independence of the court from another arm of government, that sort of thing. I think it would be a full-time job if one actually went nitpicking through all the things that are said about what's happening in the court or what is said in judgments. With long and complex and judgments that the public might be interested in, quite often the court will issue a summary not forming part of the reasons. The High Court does this as well. I think in all their cases, because by definition, public interest. But probably once or twice a year, or I think there's an interest of the public in having a short version of the essential reasoning. I'll do a summary, and then the journalist can use that. I think that's useful because I think it's a two-way street. I'm not saying that the journalists are very capable of understanding what the court does, but quite often what the court does is it's hard work for somebody who's a busy journalist to understand the essence of it.
I think I wouldn't be surprised if the issues come up more and more now that the Australian Associated Press is shutting down. So I think they're responsible for quite a lot of the court reporting in Australia.
Yeah, I think that's probably true. So I think the court has an interest in helping journalists and the public understand what the cases are. Of course, the biggest amount of ink is spilled, I might say, probably on criminal trials, which as I said we don't do a lot of, and certainly in some parts of the press disagreeing with criminal sentencing, which we don't do either. So we're spared that aspect.
We might have one more question from Andrew Ray and then move to some concluding remarks.
Yeah.
Andrew asks, the ban on jury trials in the ACT is now subject to a High Court challenge. I might add as a footnote that I think ANU's Professor James Delios is acting for the accused in that challenge. But Andrew asks, do we still need juries or can judges decide cases?
Well, there's been a great shift over the last 40, 50 years in the use of juries in civil trials. I think if you go back to, before my time, if you go back to the 1940s, 1950s, most or many civil trials in New South Wales were jury trials. You only get them now in some defamation cases in the Supreme Court. So that's the civil side. So that answers the question. Yes, the judges do decide those cases, and I don't think anybody seriously is unhappy with that. Then, of course, you've got the criminal side, and for serious Commonwealth offences, of course, you've got Section 80 of the Constitution, which requires trial by jury in those cases. Judges can decide cases. I think I'm of the school that juries have an important function, and I think the important function is what I call a question of legitimacy and participation. That is, getting the ordinary citizenry involved in criminal justice system, I think is very important. I won't go into detail now about whether juries always behave in an expected way or not, but I think it's important that the ordinary citizens are involved in the criminal justice system.
I might seek an indulgence and ask a question which is faintly related, very interesting, which has just come in from Caitlin O'Brien, and that's a question which touches on judicial legitimacy. She asks whether you think that judges have diverse views of legal method. For instance, do you think that judges believe fundamentally in the objectivity and neutrality of law, or is there some difference of opinion about that sort of matter?
Look, it's not something that you discuss with anybody on a daily basis or at all, really. I suppose it's reading between the lines, trying to glean what assumptions there are. Look, I don't think judges, can't speak for them as a group really, but I'd be surprised if anybody actually thinks that the law is sort of automatic in any sense or objective in that sense. And the very notion of judging is that certainly fact-finding is highly evaluative with approaches to law. Again, I think most judges would be realistic enough to think, well, at the margins anyway, we are developing the law and therefore in that sense making new law, not on the sense of bigger steps which the High Court makes, but in the day-to-day administration of justice, deciding cases, I think there must be choices to be made rather than, well, the law tells me that there's only one answer. I'm not sure whether that captures the entirety of the question.
I think it's a good answer to the question, Judge. And just to conclude, do you have any observations about why someone might become a judge?
Well, I think if it's anything, ultimately it's going to be sort of satisfaction of contributing to the state, as it were. That might sound a bit abstract and old-fashioned. Sir Gerard Brennan, who was the Chief Justice of the High Court for some years, wrote an article which I'll give you the citation of, because if you want to look it up, it's well worth a read. It's called "Why Be a Judge?" and he published it in 1996 in the volume 14 of the Australian Bar Review, in page 89. And in particular, if you look at page 96, and I'll just read you one sentence, I think. The satisfactions of judicial life of necessity flow from an inner conviction of the service of society in a pivotal role, from the satisfaction of the aspirations of litigants, of the profession, of the public, and most importantly of oneself, and, I'm not sure about this, the mutual esteem of judicial colleagues. But
aspirational.
Yes, there is a lot of satisfaction in, I think, solving problems. The most difficult part of it, I think, is probably deciding cases which haven't been competently argued, or where there's an imbalance between how a case has been argued on one side and the other, to go back to litigants in person. It's hard work, but rewarding work, I think.
Well, thanks very much, Judge, for answering those questions. I'm sure people found it interesting, and I think now we'll go back to Heather for some concluding remarks.
Thank you, Judge and Will, so much for your time this evening. It was fabulous to hear some more of your journey and to get your expertise and experience. I know I could stay online for longer. I have many, many more questions, but I'm hoping that over the coming years, fitting in amongst your retirement plans, there will be the opportunity to welcome you physically on ANU campus and to continue many of these wonderful conversations. Unfortunately, because of the format, we can't now give you the customary round of applause, but if you can accept on behalf of all of the students in attendance, our sincere thanks for your time this afternoon and our very best wishes for your retirement. And Will, we hope to see you again in person soon and enjoy the next phase of your career. So thank you both very much.
Thank you. Thank you.